One of the easy questions when we talk about patent is which is the duration of a patent? And the answer is usually 20 years from the date of the application. Easy. However, for some patent and for pharmaceutical patent, this answer is not so straightforward. Since the 90s, in Europe and in Italy, it was established the so-called SPC, or Supplementary Protection Certificate, which extend the duration of a patent in order to compensate the patentee from the delay in the actual marketing of a product because of the need to obtain a marketing authorization for a pharmaceutical product. Now, the way in which this extension is calculated may be not so interesting. You get a maximum of 5-year extension, and you have to look to the time between the filing of the patent application and the grant of the first marketing authorization within the European Union. But the real problem is that now you get a supplementary protection which is not a patent and which is not limited to the pharmaceutical product as actually marketed. Probably when the lawmaker wrote down this regulation, was thinking that you do not extend the patent and you get something in between the patent scope and the single medicinal product. However, this did not work, and the Court of Justice is receiving more and more referrals because it's not so easy to understand which is the correct scope of protection. One of the most recent decisions is the medieval decision given by the Court of Justice at the end of last year, where they look in details at the possibility to have a patent which covers certain active principle, while the medicinal product includes that principle and some other principle, combination medicinal product. And according to the Court of Justice, it is possible to extend the protection, to grant an SPC, even if this case. However, you have to look at the patent and double check that the product which is actually marketed, it is at some extent covered by the patent, and the API, the active principle, are included in the patent claim. This is for sure something which helps us to understand the SPC system, but probably is not enough, because we still have to understand if we have an extension of the patent or we have something which has a more limited scope of protection which corresponds more or less to the product on the market. And the Court of Justice did not yet answer to this question, at least for the time being. Let's see what's going to happen in the next month.